I've asked Brittany DeVries, our firm's client services specialist, to join me and ask the top 5 questions she gets asked each day from child custody and visitation clients of our firm. Maybe it will help you. I hope it will. So let's hear that first question.
Van, a question I often receive from callers regarding custody and visitation is, could I actually lose access to my child in a custody or visitation case?
Very rarely will you lose access to your child. Only in the most egregious situations, when usually the Department of Social Services has been called in, is it possible for you to lose access to your child over egregious facts like abuse, neglect. The facts are very severe, and usually the party that's guilty of them knows well in advance of the problems with it, and so, no. But what could happen in your case, is you lose the amount and the frequency of access to your child that you've come to enjoy. So it is sometimes common for courts to award only alternating weekends, maybe a midweek meal, and so if you want to maintain the frequency of contact that you've come to enjoy, meet with an attorney early and prepare your case well to ensure that you get the access that you've come to enjoy and the frequency of that access to your child that you've come to enjoy.
Bam, what is the standard that the courts use when deciding custody and visitation for my child?
No matter if you have an easy case or a really hard custody and visitation trial ahead of you, the standard at issue is what are the best interests of this child in developing the plan. So what are the best interests of the child? That's kept paramount, it's kept at the top of everyone's mind. So no matter what your co-parent's throwing at you and all the crazy facts, the standard that's kept at issue is what are the best interests of the child, and are we keeping that in mind with the plan we're creating? And so our case narrative has to be developed around the best interest of the child.
Who is the GAL, and why is that person so important to my case?
People come in and they go, GA what? In our cases, and what I say is, look, the GAL stands for Guardian Ad Litem Attorney. And what the Guardian Ad Litem Attorney does is they're appointed by the court as the ambassador, the attorney for the child. So when mom has her attorney, dad has his attorney, the child also has representation. That attorney has met with the child if they're of an appropriate age. They've met with each parent, most of the time at their home, and then developed a report that they present to the court in tandem with our presentation to the court and the other side's presentation to the court, if we have to go to court, of what's in the best interest of the child. And so the Guardian Ad Litem is an essential player, and it's also a key party to involve in your case from an early stage, giving them the information they need, communicating well, and presenting your side to the Guardian Ad Litem so they understand your position and why you've reached it is critical early on to the success of your case.
Do I have to go to court to decide custody and visitation of my child?
You don't. Just like in a divorce, if you have an agreement from both sides, we can memorialize that understanding between the parties out of court at our settlement table in what's known as a consent agreement. And we focus on those. We provide consent agreements to many of our clients where after several sessions, sometimes one, sometimes over a course of weeks, we develop a plan for custody and visitation outside of court, memorialize that understanding in a consent agreement, and then without ever setting foot in court, the attorneys go, or the attorney, just one, can go and present that consent agreement and have the court enter a consent order to then memorialize your understanding and make it legal and then allow you all to live your life without ever having to go through the trauma and the anxiety of a courtroom custody battle.
Van, what is the typical court case like for a custody and visitation hearing?
By the time you get to the moment where you're walking into that courtroom for your custody and visitation case, you will have had several meetings with us to prepare you, so you'll be walking into that courtroom far more confident than you feel right now. At the beginning, everything seems impossible and it seems overwhelming, but by the point where we're walking into that courtroom, in phases we'll have developed your case, educated and prepared your witnesses, brought together and organized exhibits to make your best case, make your best trial presentation. So you'll have walked into that courtroom rehearsed, ready, prepared, and confident in ways that you can hardly imagine right now at the beginning. And that's why it's important to pick a professional and pick a team that focuses on educating and empowering clients. So when you walk into one of the toughest days in your life, that courtroom, for your custody and visitation of your children, you're with a team that gets it, that understands what's at stake, and has prepared you thoroughly, so you walk into that courtroom with confidence and ease. So I understand how hard it must feel and impossible it must feel, but we're ready.
Van, one bonus question that I have from callers that I often receive is, what do I do with all those text messages that keep coming in from the other parent?
We don't live in a pen and ink world anymore, I get it. We have iPhones, smartphones, and when we get upset or the other parent gets upset at us, they're sending us nasty text messages. And I understand that that's the world we live in. It's important to join and be part of a law firm that understands that technology and can use it effectively in court. So if you're getting mean or nasty text messages that are not showing good co-parenting skills by the other parent, first save them, and then choose a firm that understands and gets how to use those text messages effectively in court to be successful. So we welcome your case, save those text messages, we'll use them later.